After studying this module, we shall be able to understand the concept of key managerial personnel, learn the process of appointment of key managerial personnel in a company, get a complete understanding of provisions related to managing director, learn the concept of whole-time director and manager, know the points of differences between managing director, whole-time director, and manager, know the provisions relating to the managerial remuneration.
As per Section 2, subsection 51 of the Companies Act 2013, key managerial personnel in relation to a company means the Chief Executive Officer or the Managing Director or the Manager, the Company Secretary, the Whole-time Director, the Chief Financial Officer and such other officer as may be prescribed. Board of Directors usually appoint managerial personnel such as Managing Directors, Whole-time Directors, also known as Executive Director, and a Manager, that is, the Chief Executive Officer, to manage the affairs of the company under the superintendence and control of the board. Section 196 does not allow the simultaneous appointment of a managing director and a manager in a company, but a company is permitted to appoint more than one managing director.
The following whole-time key managerial personnel, managing director or chief executive officer or manager, and in their absence, a whole-time director, company secretary, and chief financial officer, provided that an individual shall not be appointed or reappointed as the chairperson of the company in pursuance of the articles of the company, as well as the managing director or chief executive officer of the company at the same time after the date of commencement of this act, unless: first, the articles of such a company provide otherwise, or second, the company does not carry multiple businesses. Provided further that nothing contained in the above provision shall apply to such a class of companies engaged in multiple businesses and which has appointed one or more chief executive officers for each such business as may be notified by the central government. As per section 203, subsection 2, every whole-time key managerial personnel of a company shall be appointed by means of a resolution of the board containing the terms and conditions of the appointment, including the remuneration, restriction on number of offices to be held. A whole-time key managerial personnel shall not hold office in more than one company except in its subsidiary company at the same time. However, a whole-time key managerial personnel may be a director of any company with the permission of the board. It is further provided that a whole-time key managerial personnel who is holding office in more than one company at the same time on the date of commencement of this act shall, within a period of 6 months from such commencement, choose one company in which he wishes to continue to hold the office of key managerial personnel. Number of managing directorships. As per section 203, subsection 3, A company may appoint or employ a person as its managing director if he is the managing director or manager of one and of not more than one other company. However, such appointment or employment is to be made or approved by a resolution passed at a meeting of the board with the consent of all the directors present at the meeting and of such meeting, and of the resolution to be moved thereas specific notice has been given to all the directors then in India. Filling of vacancy. As per section 203, subsection 4, if the office of any whole-time key managerial personnel is vacated, the resulting vacancy shall be filled up by the board at a meeting of the board within a period of 6 months from the date of such vacancy. Penalty provisions. As per section 203, subsection 5, if a company contravenes the provisions of this section, the company shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees, and every director and key managerial personnel of the company who is in default shall be punishable with a fine which may extend to 50,000 rupees, and where the contravention is a continuing one, with a further fine which may extend to 1,000 rupees for every day after the first during which the contravention continues.
Let us now discuss the provisions relating to managing director. According to section 2, subsection 54 of the Act, managing director means a director who by virtue of the articles of association of a company or an agreement with the company or resolution passed by the company in a general meeting or by its board of directors is entrusted with substantial powers of management of the affairs of a company and includes a director occupying the position of a managing director by whatever name called. A managing director has essentially to be a director. A managing director will cease to be a director the moment he ceases to be a director. A managing director of a company has to exercise his power subject to the superintendence, control and direction of the board of directors.
The appointment of a managing director can be made either by an agreement with the company or a resolution passed by the company in the general meeting or a resolution of the board of directors or a clause in the articles or association of the company. As per section 196, subsection 4, a managing director, whole-time director or manager shall be appointed, and the terms and conditions of such an appointment and remuneration payable subject to the provisions of section 197 and schedule 5 be approved by the board of directors at its meeting. The appointment and remuneration payable, however, shall be subject to approval by a resolution at the next general meeting of the company and by the central government in case such an appointment is at variance to the conditions specified in Schedule 5 of the Act. Section 196 subsection 5 further provides that where an appointment of a managing director, whole-time director, or manager is not approved by the company at a general meeting, any act done by him before such approval shall not be deemed to be invalid. Term of office of managing director. As per section 196 subsection 2, no company shall appoint or reappoint any person as its managing director, whole-time director, or manager for a term exceeding 5 years at a time, provided that no reappointment shall be made earlier than 1 year before the expiry of his term. Section 196, subsection 3 provides that no company shall appoint or continue the employment of any person as managing director, whole-time director, or manager who, first, is below the age of 21 years or has attained the age of 70 years, provided that appointment of a person who has attained the age of 70 years may be made by passing a special resolution, in which case the explanatory statement annexed to the notice for such motion shall indicate the justification for appointing such person. Second, is an undischarged insolvent or has at any time been adjudged as an insolvent. Third, has at any time suspended payment to his creditors or makes or has at any time made a composition with them, or fourth, has at any time been convicted by a court of an offence and sentenced for a period of more than 6 months.
Let us now discuss the powers and duties of Managing Director. A Managing Director is appointed to manage the affairs of a company. His powers and duties usually are defined by A. The agreement with the company by which he is appointed, or B. By the memorandum and articles of association of a company, or C. By the resolution of the shareholders or the directors. A managing director is entrusted with substantial powers of management. His powers may relate either to a particular division or divisions of the business. This follows that there may be more than one managing director in a business. A managing director is required to exercise his powers subject to superintendence, control, and direction of the board of directors of the company. Since a managing director must be a director, he has also the duties, responsibilities, and liabilities of an ordinary director. Also, the power to do administrative acts of a routine nature when so authorized by the board, such as the powers to affix the company common seal to any document or to draw and endorse any check on the account of the company in any bank, or to draw and endorse any negotiable instrument, or to sign any certificate of share, or to direct registration of transfer of any share, shall not be deemed to be included within the substantial powers of the management.
Related to whole-time director, according to section 2 subsection 94, Whole-time director includes a director in the whole-time employment of the company. He may be taken as a director who devotes his whole or substantially the whole of his working time to work with the company. Thus, whole-time director is an employee director of the company. He does not exercise substantial power of management, but performs important administrative functions. Regarding the appointment of whole-time director, the provisions of Section 196, which are applicable to the appointment of a managing director, are also applicable to the appointment of a whole-time director. Let us now discuss the provisions governing the manager. According to Section 2, subsection 53, manager means an individual who, subject to the superintendence, control, and direction of the board of directors, has the management of the whole or substantially the whole of the affairs of a company and includes a director or any other person occupying the position of a manager by whatever name called, whether under a contract of service or not. Appointment of manager. Provisions which are applicable to the managing director regarding appointment, term of office, and number of companies which can be managed also apply to a manager. Let us now discuss the managerial remuneration. The term managerial remuneration includes remuneration payable to the managing director, manager, and the whole-time and other directors. It does not include remuneration paid to technical advisors or secretary. Besides that, remuneration paid to a person of the category of managerial personnel for duties performed by him which cannot be termed as managerial shall not be called managerial remuneration. Example: remuneration received by a director for working as a secretary or technical advisor. But if a person is designated as a secretary but performs the functions of a director or manager or managing director, then his remuneration will be included in the definition of managerial remuneration. Section 197 of the Act provides that the total managerial remuneration payable by a public company to its directors, including managing director and whole-time director, and its manager, in respect of any financial year, shall not exceed 11% of the net profits of that company for that financial year, computed in the manner laid down in Section 198, except that the remuneration of the directors shall not be deducted from the gross profits. However, the company in general meeting may, with the approval of the central government, authorize the payment of remuneration exceeding 11% of the net profits of the company, subject to the provisions of Schedule 5. Overall limit on managerial remuneration. It is further provided that, except with the approval of the company in general meeting, the remuneration payable to any one managing director or whole-time director or manager shall not exceed 5% of the net profits of the company, and if there is more than one such director, remuneration shall not exceed 10% of the net profits to all such directors and manager taken together. The remuneration payable to directors who are neither managing directors nor whole-time directors shall not exceed: first, 1% of the net profits of the company if there is a managing or whole-time director or manager; second, 3% of the net profits in any other case, as per section 197 subsection 2. The percentages aforesaid shall be exclusive of any fees payable to directors for attending board's meetings or a committee thereof. As per section 197 subsection 3, in a financial year, if a company has no profits or its profits are not adequate, the company shall not pay any remuneration to its managerial personnel, exclusive of any fees payable to the directors, except with the previous approval of the central government. However, the consent of the central government is not required if the managerial remuneration is as per the provisions of Schedule 5. The remuneration payable to different categories of managerial personnel can be summarized in the table as shown here. The overall limit for total remuneration to all managerial personnel is 11% of the maximum percentage of annual net profit for the managing director for one is 5%, for managing directors more than one for altogether it is 10%, for the whole-time director for one it is 5%, for the whole-time directors more than one for altogether it is 10%, for the manager there cannot be more than one manager, it is 5%, for the managing director or manager with one or more whole-time director or directors for altogether it is 10%, for the directors for all when there is no manager or managing director or whole-time director it is 3%, for the directors for all when there is a manager or managing director or a whole-time director it is 1%. Section 197 subsection 4 provides that the remuneration payable to the directors of a company, including any managing or whole-time director or manager, shall be determined in accordance with and subject to the provisions of this section, either by the articles of the company or by a resolution, or, if the articles so require, by a special resolution passed by the company in general meeting, and the remuneration payable to a director determined aforesaid shall be inclusive of the remuneration payable to him for the services rendered by him in any other capacity, provided that any remuneration for services rendered by any such director in other capacity shall not be so included if, first, the services rendered are of a professional nature, and, second, in the opinion of the Nomination and Remuneration Committee, if the company is covered under Section 178, subsection 1, or the Board of Directors. In other cases, the director possesses the requisite qualification for the practice of the profession. As per Section 197, subsection 5, in addition, a director may receive remuneration by way of fee for each meeting of the board or a committee thereof attended by him, provided that the amount of such fees shall not exceed the amount as may be prescribed as per Section 197, subsection 6. A director or manager may be paid remuneration either by way of a monthly payment or at a specified percentage of the net profits of the company, or partly by one way and partly by the other, as per Section 197, subsection 9. Any remuneration drawn and received by any of the managerial personnel in excess of the statutory limits shall be required to be held in trust for the company and shall be refunded to the company. As per Section 197, subsection 10, the company cannot waive the recovery of any such sum paid in excess. As per Section 197, subsection 12, every listed company shall disclose in the board's report the ratio of the remuneration of each director to the median employee's remuneration and such other details as may be prescribed. As per Section 197, subsection 13, where any insurance is taken by a company on behalf of its managing director, whole-time director, manager, chief executive officer, chief financial officer, or company secretary for indemnifying any of them against any liability in respect of any negligence, default, misfeasance, breach of duty, or breach of trust for which they may be guilty in relation to the company, the premium paid on such insurance shall not be treated as part of the remuneration payable to any such personnel. However, if such person is proved to be guilty, the premium paid on such insurance shall be treated as part of the remuneration. As per Section 197, subsection 14, any director who is in receipt of any commission from the company and who is a managing or whole-time director of the company shall not be disqualified from receiving any remuneration or commission from any holding company or subsidiary company of such company subject to its disclosure by the company in the board's report. As per Section 197, subsection 15, if any person contravenes the provisions of this section, he shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees.
Key managerial personnel in relation to a company means the CEO or the MD or the manager, the company secretary, the WTD, the CFO and such other officer as may be prescribed. Board of Directors usually appoints managerial personnel to manage the affairs of the company under superintendence and control of the board. Section 203 of the Act provides that every listed company and every other public company having a paid up share capital of rupees 10 crores or more shall appoint the key managerial personnel. Managing director is a director who is entrusted with substantial powers of the management of the affairs of a company and includes a director occupying the position of a managing director by whatever name called. A managing director has essentially to be a director. A managing director will cease to be so the moment he ceases to be a director. Whole-time director includes a director in the whole-time employment of the company. Manager means an individual who, subject to the superintendence, control and direction of the board of directors, has the management of the whole or substantially the whole of the affairs of the company. Section 197 of the Act provides that the total managerial remuneration payable by a public company or to its directors, including managing director and the whole-time director and its manager in respect of any financial year, shall not exceed 11% of the net profits of that company for that financial year.